Hello, everyone. Happy Thursday. Welcome to our monthly webinar. This month we have attorney John Dunnell joining us, and he's going to be talking to us about estate and tax planning with your IRAs. Without further ado, attorney John Dunnell, please take it away.
Hello, everyone. We've got a good turnout today, so thank you for taking some time away from a beautiful summer day to come and listen to me talk about things that I know you're all here to hear about because you probably have them, IRAs. So we're going to talk in two parts today. We're going to talk part one. We're going to do overview and some basic concepts and some tax planning ideas when it comes to IRAs, and then we're going to part two. We're going to kind of work it into our estate plan. If you've done one or if you haven't done one and you're going to do one in time, it'll be good to know and think about how to work your IRA into your estate planning goals. So I got to start off with some housekeeping and some lawyerly type stuff and say a disclaimer here. So this presentation is meant to be a general overview of estate planning and should not be considered as legal advice. You should consult an attorney in your estate to determine the legal requirements that apply to your individual situation. All right, so next slide, we can look at the table of contents here that we'll be going through and a lot to cover. So I'll try to move it along. Like Ali said, I won't, seek questions until the end, except maybe at one part. I might just check in with you to make sure that everyone's following along. And if there's confusion or if there's any questions on one particular slide, I may ask you at that time. But you can see we're broken up into the basics as part A of today, and then part B, estate and tax planning with our IRAs. Next slide. So as a general overview start, we've really got generally two types of IRAs. And one being a traditional IRA, the other being the Roth IRA. Under traditional, you might also add SEP IRAs or simple IRAs. So when we're talking about a traditional IRA versus a Roth IRA, what are the differences? What are the main differences between the two? The first is under a traditional IRA, you may receive a tax deduction when you contribute to that IRA. I only say may because it depends on a number of factors. Also, whether you're doing it through an employer, and also whether you have certain income limitations that might apply. But very most often, when you're dealing with a SEP IRA, traditional IRA, simple IRA, you're getting a deduction on the way in for your contribution. The difference there with your Roth IRA is you're not. So contributions are not deductible. Doesn't sound good at first. As we get into the Roth IRA, it's going to get better. We look at the next line. For traditional IRA, investments grow tax deferred, as opposed to Roth IRAs where investments grow tax free. So there's a big distinction in those phrases there, tax deferred versus tax free. What are we talking about? When it's tax deferred, really what we're saying is that during the life of the IRA, as long as the money's in there, you'll not be paying income taxes on the growth inside the IRA. But when it comes out, you will pay income taxes. Whereas in the Roth IRA, not only do you not pay income taxes while the monies are in the Roth IRA, but you also do not pay income taxes when you pull the money out of the Roth IRA. So there's the major distinction between the two IRAs. On the third line, reaffirming that withdrawals are generally taxed as ordinary income out of the traditional IRA. Roth IRA, your qualified withdrawals are tax-free. And the word qualified, I think, really oversimplifying, meaning that you don't take it out before 59 and a half, and you keep it in there for at least 5 years from your establishment. First, initially establishing the Roth IRA, you can take everything out tax-free. On the traditional IRA, RMDs, we're going to talk a lot about those in a minute. They must begin at age 73. What do we mean by RMDs? We mean the how soon and how much the IRS is going to require you to draw on your IRA. This must begin at age 73 for those who were born in 1951 through 1959. As opposed to 1960 forward, they moved that up to age 75. On the Roth IRA, no RMDs are required at all during the participant or owner's lifetime. And even if the surviving spouse, if she rolls it over to her own IRA, does not have to draw any money out during the surviving spouse's lifetime either. So let's look at an example of this, see how it works. You contribute $10,000 and it grows to 50,000. Well, if that happens with a traditional IRA, you're getting your deduction for $10,000 going in, and we withdraw the 50,000, the entire amount is taxable income to you. Whereas the Roth IRA, you put the 10,000 in, you don't get a deduction for the money going in, but the entire $50,000 can be withdrawn tax free if done after age 59 and after 5 years from having set up the Roth IRA. Next slide. So with a traditional IRA, main thing on that category there, that's that side of the slide. The money is going to come out as ordinary income, taxable as ordinary income. To avoid penalty, you need to wait until you're at least 59 and a half to take it out. Roth IRAs are a little bit more tricky. Contributions not deductible, as we talked about. And for that reason, you can withdraw your contributions at any time without penalty. So even if you were not 59 and a half, or even if changed your mind within 5 years of setting up the Roth IRA, you can pull the money you put in out without any penalty. But if you're before 59 and a half years old and you try to pull more than your contribution to your Roth IRA out, you will be penalized on the earnings if you draw them out before age 59 and a half. So next slide. Now, what is this thing called required minimum distributions, and what does it all mean? This is describing what and when the IRS says you must take out your money from your IRA. And remember, as we talk about this, as we go through this whole presentation today, you can always take out more than the minimum, right? You can always take out as much as you want to. IRS doesn't mind that. IRS is happy if you take it all out. They get their tax revenue. But what the IRS doesn't want you to do is keep your IRA forever. Your life, your spouse's life, your children's life, and never, ever, ever have to take any out. Too much of a benefit, they say. So there has to be required minimum distributions. And what accounts are subject to these? Well, your traditional IRAs, your SEP IRAs, simple IRAs, 401ks, 403bs, they all have RMDs. What's missing from that? The Roth is what we at the bottom here. They don't require any distributions during the owner's lifetime, or even the spouse of the owner if she rolls over the owner's Roth IRA after the Roth IRA owner's death. Going to the middle of our slide here, the current RMD age requirements. When do you have to take your first distribution from your traditional IRA? Well, if you're a baby boomer still, then it's age 73, so 1951 to 1959. If you're a Gen X, 1960 or even later, or millennial, Z, everything, age 75. So, pretty generous in those terms. Some of you will remember the days when, or some of you are already taking money out when you knew it was 70 and a half was the age that you had to begin to take distributions. So that was moved up during the so-called Secure Act changes that were made several years ago. And the specific date is April 1st of the year after the year you reach the applicable RMD age. So if we look at an example, if you were born in 1955, your RMD age is 73. And if you turn 73 in calendar year 2028, your first required distribution has to be taken by the following year, April 1st, 2029. Now, if you do that, you have to take your second one out, that being 2029 being the second year of a distribution you have to take. You'd be taking it out in the same year. So you'd be doubling up in 1 year, which most people don't want to do because it puts you in a higher tax bracket by having to double up on your distributions from your IRA. So very typically, when you reach the age that you have to take a distribution, you take it in that year. And as I mentioned, the Roth accounts at the bottom, no required distributions during your lifetime, and if done right, your spouse's lifetime. But when it gets to the kids, gets to the next generation, then the money has to come out. We'll talk about the rules for that in a few moments. So we can go to the next slide and then really get down to something. I think this slide could be helpful to you. I'm going to say this because even though entities like Fidelity, maybe even your local bank, even if it's a smallish bank, they're gonna tell you what your RMD is very often. And most of the time they're going to be right. But um, I think it's always helpful if you can, run a double check on them to make sure they're right. So I'll give you what you can with this slide to do that. So starting at the top for persons who contributed to the IRA, or we call them the IRA owner or the IRA participant, and the surviving spouse of such participants who roll over the IRA to their own IRA, then the annual required minimum distribution is calculated using this relatively simple formula. The RMD is equal to the prior year's December 31st IRA balance divided by what we call life expectancy factor, which we get from IRS or say Treasury tables, which are widely available, especially these days with ChatGPT and everything, or at least Google. You can go and get these tables. We call it a uniform table that applies to an IRA owner and or his spouse. The table is very generous. It's really based on the presumption, just to make it uniform across the board, of someone who's married to somebody who's 10 years younger than themselves. So that's basically the life expectancy table. It's a joint and survivor type calculation. So what do we do with this information? Well, we'll go 1, 2, 3 here on this. Number one, first thing we want to do is determine our IRA balance that we need to do our calculation with. And as I said, that's December 31st of the year before the year that you have to take your distribution. That is what we call, if you remember back in middle school, high school, our numerator that goes on the top of the divisor line. So for in our example where we had someone born before 1960 who turned 73 in 2028, they're going to take their distribution out in that year, December of 2028. So what they do is go back and look at what the value of their IRA was on December 31st, 2027. Now, you can go to your bank statements or investment statements to do that, but your provider, Fidelity, for example, is required by law to file with the IRS and you what's called a 5429. I think I have that number right, form. Some of you may remember those and see them, and what am I supposed to do with these? And you give them to your CPA or tax accountant. Well, that's telling you and telling the IRS what the value of your IRA was in the previous year, so you can do this required distribution. So that's our numerator. Number two on our slide here, you find your life expectancy factor. This is your denominator. This goes in the bottom line of your division. And as I mentioned, they're using this thing called the uniform table. Here's what it looks like. You go to the table, you look up your age, and it'll tell you what your denominator is, what your divisor is. So for someone who's just turned 73, in our example, we'll see that it's 26.5. And when you think about that, sounds pretty generous, right? Because remember, It's not just your life expectancy, it's a uniform table that presumes you're married to someone 10 years younger than you, and it's using a joint and survivor life expectancy. And the other thing you can notice by looking at this, if you move forward, you can see 73 to 74 drops by 1 digit, but if you go further, you see it doesn't drop by 1 every year, which just simply means as you get older, the chances of you living longer extends. So with this kind of a table, it never ends. It never gets down to zero, meaning your IRA, unless you live well over 100 years old, never gets down to zero either. The required distributions from your IRA, that is. Always helpful to have an example. If you look at number 3, the IRA balance on December 31st, 2027, let's suppose is $500,000. There's our numerator. If the first distribution is taken in 2028, the participant is age 73, right? We said, and therefore their life expectancy factor is 26.5. So all you simply do is you take your $500,000, you divide it by 26.5, and now you know what you have to take out for in calendar year 2028. In our example, someone the age of 73 with 500,000 on that December 31st, uh, 2027 is taking out $18,868. Okay. I was thinking I might want to ask questions about that, but I'm also afraid that if I do that, let's do this because there's a lot of you. So um, if there's a question on this one, I don't know if Allie will say we can, but we can try to circle back to it and look at it together. If we get a question on it, if we can't, I've got my slide here to look at, and we can tackle the question at the end.
Yeah, we can ask it at the end with the other questions.
All right, excellent. All right, so let's go to the next slide then. Just really a continuation of what we're talking about, but now we flipped it to not the, let's say, husband and wife. We're talking about after husband and wife pass away and where it's going to go next. When I say husband and wife, it could just be a single person. So again, when it gets away from the IRA owner or the IRA owner's spouse, then what happens? Um, well, for most people, we'll get into the details of this in a few minutes. For most people, it is has to be taken out within 10 years for most people. So we'll get into that in a minute. So we'll move on from this slide for now and get back into that in more detail in a moment. Let me go to our next slide. Um, this is fun, I think, at least for me. I don't know. Some of you will say this is not, so far it's not been fun, and this doesn't look fun. But I think it's what I like about it is it gets a little closer to real world. We're all trying to figure out in retirement what we need to live on, right? So, um, and there's a number. I think we have at different times in our lives, we have a different idea what that number is. And, with inflation, cost of living, everything keeps changing, goes up, doesn't go down, right? So, unless you're fortunate. But in this example, we're saying that the 73-year-old we keep talking about, who was born before 1960, meaning he has to start taking money out at 73, he's determined he needs $100,000 a year to live on, at least. Um, and when we look at the table we have here on the slide, he's looking at his buckets, if you will, his buckets of assets or income that he's going to come up with this $100,000 for. And if we walk through each of those categories in the box, we see, by 73, he's got Social Security, of course, and he has his traditional IRA we were talking about in the previous slide. But in this case, he learned by doing the math we were just doing that he has to take out 30,000, which means he didn't have 500,000 like our previous example. His IRA is more like about an $800,000 IRA to get to that number. And then we have his after-tax accounts, or we'll call the taxable accounts. So the money he's been managed to be able to save outside of retirement accounts. He's got an investment account there, a non-IRA investment account. And he's also got a Roth IRA as well. All right. So where is he going to go to get this money? Well, some of this money is coming to him regardless of whether he'd like to go, right? As we established, number one, we're looking over to the right of the table there. Number one, we know at age 73 he has to take his 30,000. So there's our 30,000 towards our 100,000 for the year. And it's going to be taxed entirely, both federal and state in Massachusetts. Um, so number two, the Social Security is coming out too. It's scheduled. It's been set up. It's going to be $40,000. That brings him to 70,000 for the year. And that Social Security is getting taxed partially at the federal level. I think fairly, we're going to say mostly, right? Those of you who know that. Up to 85% of it's being taxed at the federal level. It's not at all being taxed in Massachusetts, and it's true in most states. But then, all right, so he's got 70 of his 100. Now the planning happens. Here's a little tax planning. Where does he want to go to get himself up to 100? Does he want to go back into his traditional IRA? I can't hear you all out there because we're not, but hopefully you're going to be saying, well, no. Again, you don't want to be taking more tax money out of something that you're going to be paying taxes on. So we really don't want to go there. We want to wait, only take the minimum on that one where we can. What about the bottom two box entries here in our chart? Uh, Both. Which one in this example here in the chart? It's showing that this person decided to take $20,000 from his after-tax accounts and took 10,000 out of his Roth IRA. If I was advising, I would say, well, let's not take anything out of the Roth IRA at all until we have to. And as I said, what does it mean until we have to? It doesn't have RMDs. If you remember the other slides we looked at, Roth accounts do not have to take out any money during your lifetime. So we don't have to. So then the question would be, well, why then? You can always go there. It's going to be there, but it's growing tax deferred. So as at the bottom of the slide indicates, drawing on items 3 and 4 are preferable to taking it out of your traditional IRA, income tax wise. But taking it out of your non-IRA investable money is better because you can get that money. You're not paying taxes on getting that money and using it. And you're not taking it from a vehicle that's growing tax deferred, like your Roth IRA. So I would revise the chart myself to say I'd want to do, if it was my investments, my holdings, I'd go, 40 Social Security, 30,000 traditional IRA, RMD, and 30,000 from my taxable investment account, and wait on my Roth IRA. And that's what I would do. Hopefully, I think many of you would say, yeah, I would do that too. But we'll see. But I'll take questions, and you can certainly try to, uh, if you want to debate me on that, it'll be fun. We'll do that later. Okay, so let's go to the next slide. And the debate could be, number one on our next slide, there are periods, we don't know enough about this age 73 person. We're kind of making this simple here. But what if he's actually in his late 60s, has retired, and doesn't need to take anything out of his IRAs? Maybe because he's got a pension, maybe because he's got other savings in his after-tax accounts. Well, in consultation with your investment advisor, your investment professional, there may be a window of opportunity to actually convert traditional IRA money into a Roth IRA. Now, we're going to get into that today because that's a whole separate topic in and of itself. But there's a lot of interest in doing that and timing it to do it the right time so that you're moving money that when you are drawing on it, you're having to pay income taxes on it later in life when you are having to take out a lot of money from taxable IRAs, and maybe taking that taxable hit now when you're in lower tax brackets to build it in a Roth IRA that you'll take out later in life if and when you need to, completely tax-free. Again, conversation for another day, but that's a tax planning option you can raise with your investment advisors. What are some of the poor things, mistakes you can make on your own, with regards to your IRA? Well, one of the big ones I see a lot in my office is people who haven't updated their beneficiary forms. And in fact, having done them years ago and never looked at them again. I mean, one of the very typical ones is when you're young and your kids are young, you name your spouse primary beneficiary, but you don't make a choice or don't get around to naming a secondary beneficiary. And then when both mom and dad have died and the kids come to our office to administer the estate, they find out there is no beneficiary because mom named dad, but dad died first. And when mom died, there was no contingent. So there was nobody. And when that happens, number one, bad thing, it has to be probated through the probate court. And the other thing, you can end up with as short as a 5-year distribution period for having to pull the IRA money out. So if there's nothing you want to take away or can take away or interested in taking away after today, after we go over everything, is the main thing would be the one that's highlighted under number 2 in bold: review beneficiary forms periodically. That'll serve you very, very well. Make sure if you say, I know it's my wife and then my kids, and I'd say, are you 100% sure? Because you're not 100% sure, get 100% sure and just double check and make sure that's true. Simple to do, save a lot of headache and maybe a lot of taxes later on. All right, next slide. Now we can get into the second part of our discussion, and that is really getting more into what I do in my practice as an estate planning lawyer, which is working IRAs into your estate plan. And we'll start by saying that why do IRAs need to be factored in? Well, it's because I think I'll speak for maybe most of us listening to this webinar today, our IRAs, 401ks, our pre-tax money, our savings are the bulk of our net worth. It's our house and it's our IRAs and 401ks. So overlooking them or not coordinating them with the trust and the will you're drafting with your estate planning attorney can cause more taxes being owed by a surviving spouse or heirs after your death. So this is really something to emphasize for today. Now, I mentioned probate earlier. What are the differences between a probate and a beneficiary designated type asset? Most assets these days have beneficiary designations. We run through the list of the things you have: IRAs, 401ks, life insurance, even some bank accounts these days. More and more bank reps are encouraging you to do a POD, pay on death, in trust for somebody. Very simple registration on banks, or a TOD of your investment account, transfer on death. These are all very, very handy and simple ways without even going to a lawyer to avoid probate of those particular assets. But as you learn when you do your estate planning, you can't do that with your home or your other real estate. And there may be some other types of accounts you can't do a designation of beneficiary for. So for many of you who do your estate planning with your lawyer, they're going to recommend, to completely avoid probate, a revocable living trust. And in its most basic form, it's not terribly complex. It's not sophisticated. It's designed to be a vehicle where you don't have a beneficiary designation to get the assets to who you want them to go to without probate proceedings. The most popular one for that is your home. All right, so leading to number 3 on our slide here. Do your beneficiary designations in your IRA override the provisions of what you said in your will and your trust? I can't do a raise your hand thing, so I can't see y'all, but I'll just tell you then that, and many of you probably know, that whatever you say in your IRA beneficiary designation form controls that IRA. It doesn't control the other assets, of course, but it controls that IRA. So, as an example, you go with your estate planning with your lawyer, you do a will or a trust. You provide equal shares to your children, Randy, Steve, and Jim. But you had forgotten that years ago, Randy being the oldest, for whatever reason you might have had, you named Randy as the sole beneficiary of your IRA. Is what you did recently with your estate planning attorney in your trust, designating equal shares to your children, going to bail you out on not having done what I mentioned in an earlier slide? Go check your beneficiary designations to make sure they're what you want today. No, your will and trust is not going to bail you out. Your will and trust will control what it can control. It might be the house, it might be anything that doesn't have a beneficiary designation associated with it. But things that have beneficiary designations, like what you did on your IRA, are going to control the IRA. So your IRA is going to go to your oldest son, Randy, and not equally, because that's what you did on your beneficiary designation form. Next slide. So what what you want to do is when you're doing your estate planning with your lawyer be doing this with you, make sure you're thinking about your IRA, working your IRA into the decision making that you're doing. Um, so uh, not only that, on this slide in number one, typically if you're married, you probably name your spouse primary beneficiary of your IRA. And as we'll get further into in the minutes to come, that really often is the most tax efficient way of doing things. It's simple, it's easy, and it's effective in most cases. And we're going to talk about these exceptions to that, and that's what we're going to get into to finish up today. But if you name your spouse and you have children and they're all adult beneficiaries capable of managing their inheritance, then you're going to typically name your children as secondary or contingent beneficiaries. Very typical and also, very effective tax-wise. Number two, spouse versus non-spouse beneficiaries. Surviving spouse could do all kinds of things with her deceased spouse's IRA that non-spouse beneficiaries cannot. The main thing that you often see is they'll roll it over to their own IRA and continue elongated distributions over the surviving spouse's life using that uniform table I mentioned that was, generously at age 73, 26.5, and then 20, and then reducing by less than one over time. So very, very beneficial. Whereas your children, in our example, your adult children capable of managing the IRA, they have to take it out generally, not generally, but specifically, unless they're an exception to a general rule. We'll talk about the exceptions. They have to take it out in 10 years. So the 10-year cap. This was recently put in the law with the Secure Act back in 2020 that children cannot use, most children, unless you fall into a special category, cannot draw it out over their life expectancy. It has to come out within 10 years. Next slide. So these inherited IRA rules to kind of run through them. Surviving spouse, most flexibility. Roll it into their own IRA, treat their late spouse's IRA as their own, and manage it effectively and tax efficiently. Most non-spouse beneficiaries are subject to the 10-year rule. That's your adult children. If they're not disabled, they would be taking it out over 10 years. What does that mean? There's a lot of confusion on this. So if we go to item 3, the annual required minimum distributions for inherited IRAs depends actually on the date of death of the IRA owner. If they die before they were, in our example back, thinking about that guy who was 73, before their required minimum distributions happened, say age 72, then the children can take it out whenever they want to over a 10-year time frame. Um, they can choose not to take anything out at all in years 1 through 9 and take it all out in year number 10 if they want to. May not always be the best way because you maybe don't want to take a gigantic taxable distribution in one tax year, but it is something that's permissive. Whereas if the IRA owner died after age 73, after required minimum distribution started, then there actually has to be distributions over that entire 10-year period, with the final distribution being done in year 10. Now, all of this is true, except if you're an eligible designated beneficiary, is number 4 on our slide. Now, if you're one of these people, and who are these people? Well, it's your spouse, but the spouse has all kinds of great advantages anyways. So now I'm thinking about who else? Minor children, disabled or chronically ill persons, or beneficiaries that are less than 10 years older than the owner himself. These people can use their life expectancy for taking distributions. Minor children up to the point where, under the definition, they're not minors anymore. We'll talk about that quickly in a moment. But they're not immediately subject to a 10-year cap. Next slide. We haven't talked so long about the Roth IRA, so we want to circle back to that and say inherited Roth IRAs, meaning, and in this case, I'm saying not husband and wife who don't have to take out any of their Roth IRA during their lifetime. But the children, adult children in our example, they do have to take it out. And they don't have to take it out for the first 10 years after the IRA owner's death, but by the 10th year, they have to draw it out. And in this instance, drawing it all out in the 10th year is not a bad thing. It's actually a good idea because over those 10 years, it can continue to grow tax-free. Take it all out in year 10. You might say, you might have forgotten what we talked about earlier and say, wait a minute, you're going to all get taxed in year 10, then you want to do that. But remember, the Roth IRA is not taxable. So you can draw it all out in year 10 and pay no taxes at all. So that's the planning idea with a Roth IRA for the kids. Next slide. Spousal planning opportunities. We've kind of touched on that as we go along, and I'm mindful of time and want to be able to answer questions. We talked about it. This is covering this is going over what we already talked about. Let's go to the next slide, which really goes to the last point I really wanted to make today, which is that most of the times you don't want to be passing your IRA through a trust. But like so many things, there's not one black and white rule way of doing things. Like you can't say never put an IRA through a trust. And we're going to look at reasons why the trust is a very useful tool in certain situations. But to step back and say, well, why do we say that at all? Well, there's really 2 primary reasons. One is trusts have very, very compressed tax brackets. A trust after $15,000 of taxable income is paying tax at the highest possible rate. Catch me off guard, 36 to 39%, somewhere in there. Whereas individuals, you're talking $400,000, $600,000 before you're at the very top tax rate, taxable income. So when you put something taxable through a trust, it can be real problematic. Not to mention the fact that if the trust isn't drafted with an eye towards the IRA coming into it, it can be disastrous in another way, in that these possibly elongated distributions that I'm talking about, the uniform table for husband and wife, and even as much as 10 years for children, or minor children or disabled children, a life expectancy, payout, uh, it may not come to fruition because of the trust language. So typically, safer named spouse, named children. As we're going to see in a later slide, I'll just touch on, you can do charities. That can be very effective for your tax planning if you're charitable and you like that. But there are situations where you're going to need to or still want to name your trust as the IRA beneficiary. And they're starting on the slide here with number two. Uh, if you have minors, we'll start on that one. Um, you can't name them. They're too young. They can't legally hold title under the age of 18 to an account on their own. So you need a trust for minor children. And thankfully, they are an exception to the limited 10-year rule. Uh, you are allowed to use for children under the age of 21 their life expectancy all the way up until age 21. And then at 21, it has to come out over the 10-year limitation. So you really got age 0 to 31 for young people to be able to draw the IRA money out. Now, you need to do it through a trust, usually for people that age. Uh, and if the trust is drafted properly, meaning go to a good lawyer who knows what they're doing with this, then you can preserve that even though the IRA is being passed through the trust. You can preserve this advantage of spreading out the distribution over a young person's life up to 31. What about special needs? If you have a disabled person in the family, a disabled child, um, you know, if you don't know, you'd figure you don't want to be naming them as your beneficiary in many cases, not all cases, but many cases, that you would want to have it go through a trust for them, special needs trust, or what we call supplemental needs trust. Um, and disabled beneficiaries have the advantage of being able to take an IRA distribution not capped by 10 years, but over their life expectancy. So, uh, and the IRS recognized that these people need trusts and therefore have made the rules relatively easy. Still got to properly draft the trust. Again, someone who knows how to draft the trust, particularly to the situation, to preserve the ability of the money coming into the trust for the disabled person over that person's entire life expectancy. And then number four on this slide, blended families. There's a lot of those out there, right? And chances are someone who's listening now is in one or more than one of you are. And in that situation, a lot of times you wanting to do two things all at once. You want to provide for your current spouse, your second marriage spouse during his or her lifetime. But you also, if you're going to go first, you're going to die first, you want to know that after he or she has enjoyed the assets or been able to live off the assets you've left them, that it's going to revert back to your children, and it's not going to go to your surviving spouse's children, or it's not going to go, to the Greek tycoon or something who comes along after you're gone. Um, so trusts work very nicely to let you do both of those things. Uh, Set it up so the trust says my wife can um, draw on these assets through my trustee for the rest of her life as she needs them. And what's left over, though, when she dies, she's not going to say where it goes. I'm going to say it's going to go back to my children. And this may be a situation, if the IRA is a big part of your assets, you feel like you need to put the IRA through the trust. Even though it may not be the best tax way, it's still something that, for practical purposes, you'll feel you need to do. And with good drafting, again, proper drafting of the trust document, you can still make the benefits going to the surviving spouse as tax efficient as the IRS will allow. So not devastating, still very, very tax efficient. Not as great as surviving spouse outright necessarily, but pretty close to that. All right. Um, so next slide, just want to shout out to our charities out there that they are very, very good options for making a beneficiary of your IRA because they don't pay taxes like individuals do. And they can receive your money, and you'll know they're getting the entire dollar on the dollar, none of it going to the government. Um, and as well as for estate tax planning, when you're doing your plan in Massachusetts, we have a very low threshold to be exposed to estate tax, over $2 million. If you're, let's say, suppose you're a single individual, perhaps your children are well provided for. You don't feel like you have to leave everything to them, or you don't have children. It can be very, very effective to leave a portion of your estate to charity, knowing that you're not going to be paying estate taxes. The government doesn't get to come in and take any of the IRA when it's going to charity, and the charity, fully benefits from it. Next slide. And I touched on the estate tax considerations again. But I'll just say quickly, when you're doing estate tax planning with your lawyer, you're going to have a whole pool of assets to choose from to try to minimize the burden of the Massachusetts estate tax. This is for our next, maybe we'll do this in 6 months when I'm back on the webinar circuit again. But we can talk about the better assets to use to minimize the estate tax burden in Massachusetts. The IRA is not the best one. There'll be others. There'll be the house, there'll be the after-tax accounts. We'll cover that at some future date. But I wanted to leave plenty of time because I'm thinking and hoping that at least one or more of you, because we covered a lot, I think relatively quickly because we needed to, but to be able to answer any questions you might have at this time.
And if you guys don't want to ask them yourselves, please put it in the chat box, and I'm very happy to ask it to John.
And we'll
That's
just
not to
wait.
say
So-
if you guys feel comfortable asking it yourselves, please do that. It's however way you guys want to ask the question.
And hopefully I didn't lose all of you all. But and there's no dumb questions with this because this is, as you can tell, we went quickly. There's a lot of details, and if it was really that easy, there wouldn't be IRA experts out there in the world who do really nothing but counsel on IRAs. So it's a tricky area of the of tax and law. And since I have time, if people are gonna if we're not hearing, hopefully we have audio, but if here we go.
All right. The question is, if your spouse is disabled or likely to be, dementia such as, would you say naming children as beneficiaries on IRAs is a good plan?
Uh, yeah, it can be. Yes. That is really goes to the heart of uh, timing with your planning. Um, if the spouse is already ill, already has Alzheimer's, I'll just say as an example, uh, and you've got this significant IRA, uh, you've really eliminated at that point the choice of your spouse being the beneficiary. And then I would say in decision making mode, you'll have a good attorney will give you two really options. One is that. One, it could be the children. Um, the other, but the danger of naming individuals at any given time. They don't teach this first year of law school. They don't teach it all in law school. You just learn it from the school of hard knocks. And we all know this law, even though we didn't go to law school. It's called Murphy's Law. Murphy's Law. Murphy's Law says whatever can go wrong will go wrong. And so if you give it to your children with the idea that they're going to have it for mom if and as she needs it, but one of them's getting a divorce or is disabled or dies or something, it can all go haywire. I think in that situation, the safer approach is to put it through a trust. And there's a particular kind of trust that can be done so that the spouse could still be made eligible for mass health government benefits if necessary, if the size of the estate makes that necessary or desirable. You can put it through a will, put it through the healthy spouse's will in the event the healthy spouse dies with this large IRA, let's say, and have it go through a will to what we call a trust under the will or testamentary trust. That and put the child in charge, put the children in charge for mom in my example here. In that way, no matter what happens to the kids, the money's protected and just for the ailing spouse. And it won't disqualify the ailing spouse from maybe giving government benefits. Again, not the best tax way, but with some proper drafting, we can make it pretty close to very good from a tax perspective. Hopefully that answered the question or answered most of it.
And then could you go over I believe it's this slide that was asked to? Yes, could we go over this slide again really quickly, please, John? That was a question asked.
Yeah, because I didn't really get to that. And if someone was here waiting for this one is the main one, the time ran out. But um, your IRA, I mean, just some of the things that I sometimes I think as lawyers obvious, but not so obvious. Your IRA, even though it's tax deferring during your lifetime, it is part of your estate for estate tax purposes. So they're gonna get everything you own in Massachusetts in terms of what's going to be part of the gross estate for estate tax purposes. So um, your IRA is part of that. And the point I was trying to make with this is that we want to try to minimize the burden of the mass estate tax, but we also want to be mindful of tax rates while we're doing that. So the estate tax you're exposed to is on the amounts over 2 million when you die, but at rates that run practically from 8%, 8 to 16%. Whereas your IRA money, when it's coming out to your spouse or it's coming out to your kids, is being taxed at more than that, right? Even if you're modest income, you're going to be at least 16, 15, 16% up to 30% tax rate. So all that being said, with typically proper planning with your attorney is going to look like, are there other assets that we can use to use the first spouse to die's exemption from estate tax? And we're going to use those. We're going to try to keep the IRA out of the mix with the spouse as the primary beneficiary for income tax purposes and try to find other assets, after tax assets, real estate, the house, after tax accounts, bank accounts to help us minimize the mass estate tax. And I know I've got other questions, so I'm going to have to cut that off, but say 6 months, I might make this the topic next time I'm doing this.
Yes, that would be a great topic. All right, next question. This one's a bit of a doozy, so please wait with me. If a trust inherits the IRA and it's used for beneficiary RMDs through the trust at the potentially higher tax bracket, can a K1 then be used to pass the taxability on the trust beneficiaries at their potentially lower individual tax bracket? Or does the trust as IRA beneficiary have to assume the tax liability of the RMD?
The answer is yes. But let me restate, also reframe the question at the same time. So the idea is the IRA is going through a trust because you've identified some reason. Let's make this person a spendthrift child or bad marriage. We see this, right? So and you're like, I want it to go through a trust for my child at least for a while. Maybe not the whole life of the child, but maybe for a while. Um, And but I know in doing that, I've just learned this, or I knew this, that compressed tax rates going to get the money. I don't want to make the government the beneficiary. So yes, so your trustee, whoever you're putting in charge of this money for, in my example, the spendthrift child or the divorcing child, um, can pass the money through the trust to the child on K1, as you referred to. You got a little bit of knowledge to be able to use that phrase. Uh, to receive the IRA money into the trust as the RMDs are going to require, and then turn around and distribute that money to the child. But then, of course, you're going to say, and that'll pass the taxation through to the child, which could be very effective tax planning. But of course, if you're following along, you're going to say, well, wait a minute, you just said he's getting divorced or spendthrift. But you can, as a trustee, not make distributions directly to the child, but you can make distributions for the benefit of. This is a big thing. It's as if you distributed it to the child, but you didn't. Maybe you're paying the mortgage on the house. Maybe you're, helping pay for the your child's children's education. So you can make these distributions that will flow through to the child in the K-1 without the child really touching the money. So that can be an effective way to try to get your cake and eat it too with a situation like that.
Wonderful. All right, another question about inherited IRAs. The company holding the funds, Vanguard, says that after last parent's death in December of 2025, the trust is the owner and there are no beneficiaries, just successor trustees. The trust details how the IRA is distributed. How is this country? The rest of the question is this contradicts what you said. What can we clarify that a bit more?
Okay. So mom and dad have passed. Did I get that right, Allie?
Yes.
And now it's going to be kids, say,
Yeah.
or whoever. But uh, yeah. So
It says the trust is the
the trust
owner
is the
of the I.
beneficiary.
Yes.
Right. The trust is the beneficiary. So, and this happens again. This may have been, all well-intended, good planning, as we've identified. Many times a trust is not a bad choice. It's needed in some cases. So, then you're having to deal with the Vanguards and the Fidelities of the world. And this is where it can get really, really, really difficult. And sometimes you need representation, unfortunately, is that very often, uh, incorrectly, it can be that they're taking the position that because it's a trust, the money has to come out. I mean, if they're really wrong, they're going to say immediately in 1 year, uh, or they'll say 5 years. Um, that's not necessarily the case. Uh, Depending again on, I will not be able to answer for you right now because it's so dependent on how the trust reads. Vanguard needs to look at that trust. Your advisor needs to look at that trust and maybe even, hire an attorney to look at it if we're talking big enough dollars here, because most trusts can and are drafted as what we call see-through trusts, where even though it's paid to the trust, if you meet four criteria, they'll call it, which I'm not going to have time to go into today, but um, you're allowed to look into the trust and say, well, it is a trust, but I can look at the beneficiaries, and it's going to be the oldest beneficiary, that person's life expectancy, or that person to whom distributions can be made at least over a period of 10 years instead of having to come out in 1 year or even, or 5 years or less. So there's a process to have to go through to do that. Very technically, without being too long on it, the IRA goes from the IRA owner's name to an inherited IRA in the name of the trust, step one. Then it can go into an inherited IRA in the name of the trust beneficiaries. That should be permissible 9 out of 10 times. You can at least throw that back at Vanguard and see where you go with that, and then maybe talk to your advisors for help.
Great. Thank you. All right. One last question. The IRA rules change. Will older rules be grandfathered in?
Hmm. Like when you're starting to take your distributions, I suppose. Yeah, well, certainly not like, if you're already age 73 and then they change the law and they're going to make it 80 before you have to take money out and you're already starting to take money out, not likely, you know. I mean, because they're looking at the, when they do tax legislation, they're always looking at the fisc, right? Looking at the tax dollars. And, they got these, they have it, it's all in sports now. It's a big problem. Or they call them the money, the people, I don't know, the numbers people running, figuring out what the tax hit, what the revenue hit's going to be. And they're not likely to do that. Yeah, I think in most cases, probably not.
All right. I think that's all the time we have for today. I just want to say thank you to Attorney John Dunnell. This was a wonderful presentation. I am not good with taxes, so I always find it very interesting. So thank you again for this presentation. Thank you everyone for joining us and have a wonderful afternoon.
Thank you, everyone. Appreciate it. Appreciate your time. Take care.